Structure of an expert's direct examination and the key issues on cross-examination are what we're going to talk about right now. Now, the first question you have to ask yourself is, why are you using an expert? Because expert witnesses have a unique place in trial. Really, experts can fulfill one of three basic purposes. First, because of their training and their knowledge, they can just help the jury or the finder of fact understand something. They can testify about how something works, and they can offer the ability for the jury to be able to visualize and understand. They can teach under ER 702. They can also, in that same context, as like a physician or an expert who is a professional in a particular field, they can offer testimony about the standard of care, what a particular specialist, say a physician or a neurosurgeon or accountant or an attorney, what it is that that particular person is supposed to do. And that can be very important in an errors and omissions case, a malpractice case. And finally, expert witnesses, because they have specialized knowledge, they can offer an opinion. And under ER 704, they can actually offer an opinion on a contested issue. Now let's talk a little bit about the structure of an expert witness's testimony. A best practice is to begin with what we call the teaser. Under the old traditional method, you would begin with a long litany of the expert's qualifications, putting in everything about them that made them expert. And the reality is that your jury or your finder of fact would be sitting there listening going, I don't understand why. I need to know all this. A better practice is to begin with what's called the teaser. And the teaser is simply a statement, and we only use it with experts. It is a statement that allows your finder of fact to understand why the expert is here. It is a leading question, and the expert has to be trained to answer yes or no and not to launch into their opinion. And the question is simply, Doctor, have you come here today to state an opinion as to the cause of death of Bruno Summers? Doctor, have you come here today prepared to state an opinion about Deborah Summers' mental health? Sir, have you come here today prepared to state your opinion as to the cause of the accident? And so that teaser starts at the very beginning. The answer is yes or no. And all it really does is it lets the jury understand why the person's here. And now they can put everything in context. But before they get to testify to their opinion, they either have to testify as to the basis for their opinion, or they have to testify to the qualifications. And actually, before they can testify to their opinion, they actually have to testify to both. Normally, we would start with their qualifications, and we want the qualifications to be specific to the opinion that you are offering. And so we would lay out what those qualifications are and give the doctor or the expert an opportunity to explain their training and experience. And that's the key phrase. Tell us about your training and experience in the area of determining the cause of death. Tell us about your training and experience in collision reconstruction forensics. Tell us about your training and experience. You see, it's an open-ended question, and it gives the doctor or the expert an opportunity to expand upon and explain their training and experience. And an expert, as you know from my cousin Vinny, an expert can have training, or they can have experience, or ideally they can have both. In many states, there is what's called the tender. And the tender is essentially a judicial acceptance of the expert. It is a, hey, wake up moment for opposing counsel because it triggers the obligation to object. And the tender essentially goes, Your Honor, at this time, we would tender Dr. Brett Mason as an expert in the area of pathology, and specifically in determining the cause of death from gunshot wounds. The tender is specific to the area in which the witness is going to offer testimony. And actually, the tender serves a useful purpose for preparation because it really focuses you on what it is that that witness is going to testify to so that your qualifications can match up. it also signals to your opposing counsel that, hey, wake up. At this point, you either have to object, you have to not object, or you have to request to voir dire the witness on the area of their qualifications. Now, as I said, that's the practice in many states. It's called the tender. Washington State does not allow for the tender because in Washington State we have a constitutional prohibition against judges making a comment on the evidence, and the tender is viewed as a comment. So we just sort of breeze right by that. We skip over that, and that means your opposing counsel has got to be sitting on the front third of your seat and waiting for you to actually delve into the opinion in order for them to either object, not object, or ask to voir dire the witness in the area of qualifications. Now, before the witness can testify as to their opinion, they have to explain how they got that opinion. What's the basis that they have it in fact, and what was the investigation? What are the things that they relied upon? And that's the basis. And then finally, ideally, we would end with, and so doctor, what is your opinion as to the cause of Bruno Summers' death? And that adds a nice dramatic moment at the end. Now, when we think about the qualifications of an expert witness, we should think about those 5 basic evidentiary issues: authentication, relevance, hearsay, best evidence, and privilege. And in the context of an expert witness, it really kind of works like this. Authentication, that's 702. Are they really an expert? Do they really have training and experience in an area of law? Relevance, do they have something to offer that relates to, is material to, and actually is probative on this particular case? And then, is the basis on which their opinion, the things that their opinion is based on, is it have a basis in admissible evidence? Now, under 703, the evidence and the information that we rely upon does not have to be admissible in most jurisdictions. Contrast Michigan, which the entire basis of the expert's opinion must be admissible. And that's why Michigan is one of the few states that actually requires you to lay out get all of the facts into evidence and then ask the hypothetical question. Generally, we don't ask hypothetical questions in states that have evidence rule 703. And then, of course, there's the best evidence rule, original documents, and whether or not there's any privilege. But the reality is, the information that the expert bases their opinion on under 703, it doesn't have to be admissible. But the expert does have to be qualified as an expert. And specifically, what we have to look at is the expert's expertness, and that is whether they have knowledge, skill, experience, training, or education that will assist, and the ability to assist the finder of fact. And we'll find the rules based on that under ER 702. But there's also a second aspect of this, and that's that the opinion itself has to be admissible under the case law. Now, in Washington State, we follow what's called the FRI, which is sort of the simpler standard. And the FRI basically is just that the opinion in the area of science has to be generally accepted in the relevant scientific community, and that the opinion is to a reasonable degree of scientific certainty, or a reasonable degree of medical certainty. That translates to more likely than not, preponderance, which is interesting because even in a criminal case, that's the basis for the admissibility of the expert's opinion. Now, that relevant scientific community, as an example, if you have a physician that is testifying within their area of expertise, and they're testifying concerning standard medical procedures, obviously that would be something in the relevant scientific community. But what if you have an expert that's testifying about and has an opinion that no eyewitness is credible, and there are such witnesses? Well, those have been held under FRI to not be generally accepted in the relevant scientific community, and also have been held to not be particularly helpful to the jury, which is a separate standard. Now, that's the state standard. Many states have adopted the federal standard, which is what's called the Dauber-Cumho standard. It's 2 different cases, and it's got 4 criteria. That the opinion is based on a theory or a technique that's been tested, that there's been peer review and publication, that there is a known, or at least it's potential to know, what the error rate is of this theory or this opinion is being offered. And finally, that it's generally accepted, sort of a Frey-esque. And in those cases, which are the federal cases, there the judge has to make a preliminary decision, usually outside the presence of the jury, that the expert witness will be allowed. So let's talk about a best practice, because frequently expert witnesses actually have more than one opinion. And in fact, their opinions can cover several different areas. So as an example, you may have a pathologist that's testifying as the cause of death, but they also may have opinions about the thoroughness of the information that was gathered. And those are really two different opinions, and their qualifications and their expertise are different in those. So they may have written articles about determining cause of death, but they also might have written articles or had special training in how to do a crime scene investigation. For those kind of witnesses, and frankly, almost every witness's opinion can be parsed down into sub or mini opinions, best practice is to use what we call mini qualifications. Break it down into discrete subsections or chapters where each time the experts ask, "Sir, do you have an opinion as to the thoroughness of the investigation at the crime scene?" And then lay their qualifications and then ask their opinion, along the way establishing the bases, the facts, what actually happened at the crime scene. And then we move into the next opinion, which might be the cause of death. It might be whether or not someone was intoxicated. But again, we ask the mini qualification question, and then we lay the qualifications. So here's your take-homes on direct. Qualifying an expert witness is both about admissibility, which is actually a relatively low standard, but the reason why we never want to waive qualifying our expert, we'll accept if somebody wants to stipulate to it, say, well, thank you, we accept that, but we're still going to do that because the jury needs to know, and the finder of fact needs to know the extent of this witness's qualifications in this area. It's just as much about persuasion of your finder of fact as it is about expertness. And many qualifications can make your expert more persuasive because your jury can see that this witness qualifications related to that opinion. Not only are the qualifications specifically related, but also that they provide credibility to the witness. So those are our two takeaways. Now let's talk briefly about cross-examination of expert witnesses. First and foremost, in terms of cross-examination of expert witnesses, beware. Recognize that there are different kinds of experts. There are experts that don't make a living at it, such as physicians or other individuals, engineers frequently, or other individuals who may have training experience, but this isn't their main job. They just happen to be doing this because they have certain knowledge that is useful. But then you have pure forensic experts, and these are very, very, very erudite and very articulate individuals. Unlike other witnesses, including physicians and others who might be walking into your turf, the courtroom, the reality is when you are dealing with a forensic expert, you're on their turf. And point blank, they're smarter than we are. They're smarter not only in the topic, but they're smarter in how to deal and present this. So we need to treat them very carefully because they will seize upon any opening, any question that is inartfully worded to be able to turn your case and to be able to persuade the jury because that's their job. They are, in a very real sense, advocates, not only for the data, but frequently for the side that hired them. So how do we cross-examine such an expert? Well, the reality is you really have to stay very tight to your one fact leading questions and enforce the yes, enforce the, and make sure that your questions are tight enough that you can enforce the yes, using the various escalating techniques that we talked about. You also want to make sure that when you ask a question, and as you structure examination, seek agreements on things that the witness must agree with. And by that, I mean you might start with the basics of the science, or those things that are important to your expert. Do your constructive cross first and seek concessions. Again, enforcing the yes, which you'll later draw upon during your closing argument and during your expert's testimony. But also remember that every expert can be cross-examined on all of the younger factors. And so run through your younger factors, because it could be that they did not perform a thorough investigation. It could be that they're having difficulty communicating the specific issue that it is that they're trying to articulate, and they get off into expert speak. And of course, they may, as a forensic expert, they may not actually have any personal knowledge. They also, say a forensic arson expert who never actually went to the scene could simply be cross-examined by saying, well, sir, you didn't go to the scene of the fire, did you? And you'll agree that you obtained your information from Chief Olson. Chief Olson did go to the scene. He smelled the ashes. He parsed through and gathered the evidence. You never went to the scene. You weren't there on the night, and you didn't go there later. So you can see a perception. And there's also the potential for interest, because, and we'll practice this in class, if an expert witness has written an opinion and was retained and wrote an opinion and was paid to write the opinion, they're not being paid for, remember, they're not being paid for their testimony, being paid for their time. But if you think this through and walk through the steps on this, if you think through that, then if they wrote an opinion, an initial opinion, that was not in favor of the person that retained them, then they wouldn't be able to bill the extra time that would be involved in presenting in court. Now, this takes a very careful setup. It's a long process. We're going to walk through that in class. Many times, experts, we see this frequently in asbestos cases and other type of litigation, experts have testified in many other cases. And so getting those prior inconsistent statements, or those prior statements where they may not have interpreted the science in exactly the same way they're interpreting it today, that can be very helpful to keep them as a control device, to keep them in line. Usually you're not going to get a prior conviction, but occasionally you will get a bad act. Specifically, sometimes experts get a little aggressive in claiming certain academic kudos that they may or may not have received. So doing your homework on your expert can really pay dividends. But with experts, unlike other witnesses, you also have 5 additional. There's the source of the information. Sir, everything you know about this case came from defense counsel. There are the specific facts, and sometimes the facts and information that they have don't exactly line up with what the evidence that actually comes in. Remember, we talked about this. The evidence that comes in sometimes is very different than the evidence and the information that you had going into the trial. And so many times you can kind of plink away at the facts, and sometimes with an honest expert, you can even turn them. You have the assumptions, that they have made certain assumptions which may turn out to be not entirely accurate. You can attack an expert's qualifications. The reality is this is the one area that an expert will defend as harshly and as aggressively as they can, because frankly, this is their living and their ego's at stake. And finally, there's the opinion itself. Sometimes, frankly, the opinion ventures into an area that really the jury already knows about, or the opinion itself just doesn't make sense. It doesn't track intuitively. So your take-homes here are this. 1 fact leading questions. Control the witness. Do your constructive first, then your destructive, and be very cautious. Get in and get out, and save the ultimate question on cross-examination. Save it for your expert, or save it for closing argument. Because if you ask the ultimate question to a forensic expert, they will explain away the points that you think that you've made. And of course, remember that unlike other witnesses, we only have the 9 areas. With an expert witness, you have 14 areas to cross. Good luck.